Hello, everyone. Welcome to Plan On It with attorney Christopher E. Botti, board certified specialist in estate planning, trust, and probate law. Chris has more than 30 years of experience helping individuals and families plan for long term care and protect what they've built. My name's Sean O'Connor, and today we're going to start something new. This is the first episode in our Ask Chris Anything series, where we answer real questions from listeners about estate planning. And if you have a question you'd like Chris to answer in a future episode, you can send your question to the email address info@bottilaw.com. That's BOTTILAW, info@bottilaw.com. We appreciate everyone who has submitted questions so far. We're going to get to those here in just a sec. And it should be great. Chris, good to see you.
Good to see you too, and looking forward to this series. It's the first of hopefully many question and answer sessions we can do from clients and potential clients. I'm super excited about it. So it's great to be here. Thank you.
Yeah, I'm sure, some of these questions get answered in the course of our other conversations, but it's nice to kind of drill in on specifics, and the people who ask them can get their questions answered. Let's get right into the first one on the list, which is, this person is asking, do I really need a living trust, or is a will good enough?
That is a very common question. It's an excellent question, and we get it all the time. And it really comes down to one word and one word only, probate. In other words, what I mean by that is if your estate would go through probate in California, you would benefit from a living trust because you would avoid that process. And so you can get away with a will as long as you have a small enough estate that wouldn't trigger California's full probate procedures. So it comes down to really the size of your estate and what's in it to make that determination of whether or not you need a trust versus a will.
Got it. So then, obviously, then the higher value my estate is, the more likely I'm going to end up having to go through probate.
Right. If you own real estate, for example, in California, you're going to go through a probate procedure, and the cost of doing that, based in California law, would be more expensive than doing a living trust if you went to a living trust for the lawyer. And so, yeah, it comes down to, real estate. Yes, it's definitely a probate. You're headed to probate if you don't plan around it, or if you have enough substantial liquid assets and they're not configured properly, you would potentially be facing a probate. So you want to make that determination, that initial determination at the very beginning. Do I have a probate estate? Yes or no? If the answer is yes, then you're going to want to opt for a trust as a far superior, more cost-effective, efficient way, private way to transfer your wealth when you pass on.
Okay, so that's perfect, because this next question is, I guess, assuming you're going to create a living trust. The question is, at what age should I create it?
Yeah, what age? So again, wealth accumulation, it can start really young. You have all these online influencers making tons of money just as teenagers potentially. And then you have people that they wait until their middle ages before they accumulate enough assets to justify doing a living trust. So it comes down to really your asset configuration. Once you start accumulating wealth and you have enough wealth that would trigger the probate process, then you're going to want to look at as a trust as a solution to pass that wealth on if you were to pass on. And so it's not age alone. It's more about when you reach those milestones of acquisition of wealth and assets that you would look to the trust vehicle as the superior vehicle to transfer those assets to your family and to your heirs.
I got it. Related to that, I have kind of a question of my own, which is, if
Sure. Ask away.
I'm there, yeah, well, okay, I'm 26 years old. I made a ton of dough in a startup company. That's enough to start a living trust or create a living trust. I'm guessing, would a trust get updated throughout my life? It's not probably a set it and forget it situation.
It's definitely not a set it and forget it situation, but you'd be surprised. There's a lot of misunderstanding about when you need to update your trust. For example, we get a lot of inquiries from clients and potential clients asking, well, I bought a home. Do I need to update my trust? Or the answer is not necessarily. If done correctly, a living trust only needs to be updated for two reasons, and that's it. So the first reason would be changing what you call your successor trustees. These are the people you would designate in your trust to take over in the event you passed on or became incapacitated. So the person or persons you choose are your successors. That's who's in charge of the trust assets once you become incapacitated or you pass on. So changing that would trigger a need to amend your documents, or the plan of distribution, where everything goes when you pass on. So those are only two drivers from a to change your documents from a client perspective if your estate plan is done correctly, not the buying and selling of assets, the transferring assets in and out of the trust. You're free to do that without having to amend your documents. It's these fundamental life changes that happen occasionally in life where you're like, say, for example, you have young children at the time you're doing your estate plan, they're not in a position to be trustees because they're not even adults. And then later on, they become adults, they seasoned enough where they're mature and they can handle that responsibility. You would amend your documents at that point to elevate your children into those roles, fiduciary roles, successor trustees, for example. So those are the drivers. Change
Yep.
who's in charge, who gets what, basically.
The next question on our list is, okay, so you're like, yes, you should create a trust. How long does the process take?
Basically, our philosophy is we go at a pace that's comfortable for our clients, and so there's not a week that doesn't go by that we get an urgent situation, either because of an illness that develops or sudden need to travel, and so we can turn around documents super fast if we needed to, literally in days, if needed. But that's not ideal from the client perspective. And so from the client perspective, you don't want to rush through this process. You want to do it in a way that you're comfortable, you don't feel hurried or pushed to get to that finish line. So we kind of basically say to our clients, look, we'll go at your pace. We're not going to rush you through this process. And so if you want to go quick, we can go quick. But we prefer that you go a little slower, more methodically, have a chance to reflect upon the decisions you're making, read the paperwork before you sign it, and ultimately make sure you're comfortable that all your questions have been answered. And so, a typical estate plan could be drafted, from start to finish, all the interactions with the clients within 30 days. That would not be what I consider a rush job. Anything shorter than a week would be considered a rush job, or 2 weeks, actually, probably. So, it's the client that really drives that.
I mean, it happens, but obviously you don't want to be doing this sort of thing under duress.
No, you do not want to be doing it under. These are really fundamental decisions you're making, and you don't want to. You want to approach it from a position of having the time to reflect and make the right decisions, not
Right.
rushing.
Right. You mentioned a couple of ways or reasons why the living trust would need to be updated. What about like and then this is the next question, the larger context of the estate plan, how often should that be updated?
Well, again, I think you should look at your documents every 5 years or so just to take a look at them, to make sure they still say what you want them to say. So you'll read the who's in charge part and make sure, okay, are my team of successor trustees still capable of doing this? Do I need to potentially consider adding someone to the list of potential trustees or removing someone from the list? Or my plan of distribution, does it still make sense? And so you should look at your estate planning documents roughly every 5 years, unless you have a fundamental life event that happens that triggers the need to look at it sooner, like a death in the family, for example.
The next question's around, okay, so the trust exists. Do I still control my assets if they're in my trust?
That's a great question. There's a misunderstanding out there that somehow when you set up this trust, you're giving away control to somebody else, that you have to answer to somebody else if you buy something or sell something or need the money from the trust. And the answer is that is not how a trust works. When you set up a living trust, you are the trustee of your own trust. So therefore, you control it 100%. You answer to nobody, and you can do anything you want with your assets without restrictions and throughout your life. And so where the trust works its magic is when you pass on or you become incapacitated, then that your successor trustee would then take over at that point and be able to implement what the trust says. And so while you're alive, you're free to do anything you want. There's no restrictions whatsoever. And that is a common misunderstanding, that somehow control is being yielded to somebody else when you establish one of these things. And that is not the case at all.
The next couple questions, kind of around assets. So this is the first one is, do I need to transfer my house into my trust?
That's another awesome question. And the answer is absolutely yes, you do. And so a trust, think of a trust as just a stack of paper, right? A legal document is a stack of paper. It's very thick. It's got a lot of language in there. And a stack of paper by itself is essentially worthless because it doesn't do
Mhm.
anything unless the trust is funded. So what we're talking about now is the funding of the trust. What goes in the trust, what doesn't go in the trust. And real estate, which is the trigger for probate, needs to be transferred to your trust by way of a deed, which we prepare on behalf of our clients. And so if you own a home, we're going to put your house in your trust. If you don't do that, your house is going to go through probate, even though you have a trust. So you want to fund it with your real estate, your primary residence, or
I
any other
see.
properties you may have.
And so the other question is around a car. Do I need to title my car in the trust?
That's a great question too. Who wants to go to the DMV, right, and wait in line to get
Right.
to retitle your vehicle in the name of the trust? Well, if you own your vehicle, in other words, you have a pink slip, okay, you don't have to transfer it into your trust, okay, under California law, unless the vehicle, and this is not going to, it's a number that changes every 3 years. It's the threshold for a probate, and that number, if the vehicle is worth more than $208,500, okay, if you have a diesel pusher motorhome, for example, or a Ferrari, then
Yeah.
you're going to want to title that in the name of the trust. Okay. But if you have a Toyota Camry, no, it's not necessary. Even a Mercedes Benz, not
Yeah.
necessary. So we tell our clients, don't worry about vehicles unless it's a really, really expensive vehicle. And then you can put it.
Yeah. Yeah. I mean, if you're a collector or that sort of a thing, it wouldn't be a factor.
You're saving
But when it is a
aggregate.
factor, when it is a factor, those
Right.
those deeds, much like the house, need to be changed over.
Yeah, we call it a pink slip in California. So your pink slip would be you go down to the DMV, make an appointment ideally, and then have them reissue the paperwork to the trust. You still own the car, by the way. You can still sell the car if you want to. Same with anything else, but that's the process, and that would be only for very expensive vehicles.
The next question here, and I don't know these initials. It's about, if the POA does not cover trust assets, what's it for then? So, first of all, what's a POA? Oh, power of attorney.
That's exactly what it means. It's the power of attorney. Okay, so
Got it.
we have documents that deal with death and documents that deal with incapacity, right? So the trust itself and the will are your death documents. They say, both documents will say, when I die, here's where my stuff goes, right? But, in terms of incapacity, if you're unable to manage your affairs financially, you will grant someone the power of attorney so they can step into your shoes and manage your finances for you. Now, the power of attorney would be for assets that are not in the trust, because not everything you own, for example, can be transferred to your trust. I'll give you a number one asset that doesn't get titled in the name of the trust: retirement assets, like a 401k or an IRA. You can't retitle that like you can with a deed into the name of your trust. So what happens is, if you become incapacitated, then you've got these assets that are outside the trust. And so the successor trustee, who is in charge of the trust assets, has the authority to deal with the assets in the trust. But you've got all these other financial functions and assets that are outside the trust. And that power of attorney gives that same person the right to sign your name and operate and deal with all the assets that are outside the trust. Together with the trust and the power of attorney, if you become incapacitated, you can designate someone to handle all matters financial for you. And so you definitely need a power of attorney because, again, not everything you own will be in the trust because it can't be there. And there's financial functions that have nothing to do with the trust also that you want to make sure you put someone in charge if you're sick and can't do it yourself.
Understood. And can that be the same person? Can your
Usually,
trustee be?
absolutely.
Okay.
So I didn't mean to cut you off. So yeah, typically your nomination for trustee would be the same person you would appoint as your power of attorney. It's normally not recommended that you parse out those financial functions where this person's in charge of the trust assets and this person's in charge of the non-trust assets. Ideally, you want the same person in charge of all of those, with very limited exceptions.
Another question, kind of on the technical side, or not technical per se, but definitions. What's the EIN for my trust?
So EIN stands for Employee Identification Number. It's a federal number issued by the IRS. And a revocable living trust does not get an EIN number. You don't need to apply for an EIN number if you have a revocable living trust. If you're single, it'd be your social security number you would use, right? And if you're married, either spouse's social security number will work. So the only time a revocable trust gets an EIN number is when if you're married, both spouses pass on, and then the trust gets assigned an EIN number, or if you're single and you pass on, the trust would get it. But while you're alive, no, there's no need to have an EIN number. In fact, your tax filing status is totally neutral. There's no extra tax filing required because of a trust. You continue to file your taxes the way you did before the trust was implemented. So it's really easy. as far as that is concerned. The IRS considers a trust a pass-through entity. It does not require a separate tax return at all while you're alive.
This is our last question in the stack, and points for candor or concision here from this listener. Mom died. Now what?
Okay, so that question could be a subject of its own podcast. We're talking about, okay, what do you do? Like the person who created the trust is no longer with us. It's called trust.
Okay, so here in this we're going to assume mom had created a trust.
Right. I mean, like, right. Well, you want to find out. I guess you take a step back. So if someone dies, like not the first question you should ask, but like early in the process of trying to figure out what's going on, it's like, did this person have a will or a trust? And let's find this document if it exists, right? You're going to want to figure that out, right? After the grieving process, of course, you don't want to start off with the first call you make is to a lawyer. That's a bad sign. So you want to look into that and figure out what did they have, if anything, whether it's a trust or a will. And if it's a trust, there's a process known as trust administration. If it's a will, unfortunately, that could be probate, and it's called probate administration. So you need to kind of figure out where you stand. And so dig up, find the paperwork, and then seek some assistance and to help interpret what that stuff means.
Good stuff. I like this FAQ format. This has been good. We really covered some ground.
Yeah, I mean, again, I think it's really important that I want my clients who are listening to this or their friends, if they have questions, this is your opportunity to ask questions of me. And I really want this series to be a regular occurrence on our podcast series, because I think this is where we get, real people asking real questions, right? And that's so important to me, and educating, people about this process. It's so fun for me to do this. And so I love doing this. And I appreciate everybody who's listening to this, by the way, too. Bring on the questions. Bring them on. I love it.
That's it for today's episode of Plan on It with attorney Christopher Botti. If you have a question you'd like Chris to answer in a future Ask Chris Anything episode, you can send it to the email address info@bottilaw.com. And to access more resources, including the 2026 Medi-Cal ebook about upcoming estate planning workshops, visit bottilaw.com. Thanks for listening. I'm Sean O'Connor. Don't forget to leave a review, make sure you subscribe, or share a link to the episode if you have someone in your world who is interested in estate planning information. Have a great day.